Yes.
Wendell Aldridge.
Yes, ma'am.
Okay, are you laying down?
Yeah.
Okay. Okay, well, you can come in person.
He's really sick, Judge.
Yeah, I'm not, you're not doing court laying down in the bed. None of those things are gonna happen. So if he's that sick, then he probably needs some time to think about what he needs to take care of before he gets a move on with court, because he's gonna have to be able to get up. And I've handled court with COVID multiple times. I didn't get to lay down and do it. And I did it from my house. So, thank you. The record in the matter of the people of the state of Michigan versus Wendell Aldridge, file number 24-00221, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people. Erin Robinson, Assistant Public Defender for Mr. Aldridge.
Okay, Mr. Aldridge, today was the date and the time that was set for your preliminary examination. And my understanding is that due to illness, you were not able to appear today. Is that correct?
Yes. Yes.
Okay. Okay, you have the right to have a preliminary examination in your felony matter within 21 days of the date that you are arraigned. And so that's why this matter was scheduled for exam today, so that we can comport with that right. However, due to your illness, the court is asking, are you going to waive the timeline so that you can have this matter reset?
Yes.
Anybody forcing you or threatening you to waive the timeline?
Say that again, ma'am.
Has anybody forced you, or is anybody threatening you to waive your timeline?
No.
Okay, we'll get you a new date. April 5th at 8:30. April 5th at 8:30.
All right.
Do you have any questions for the court?
No.
Any additional matters for the record?
Nothing for the people, Your Honor.
No, Your Honor, thank you.
You're all set, Mr. Aldridge.
Haswell in custody, Judge, but he will be acquitted. He said at 9:30 though, but I'm ready on him whenever.
Caswell.
Yes.
Okay, Ms. Donnelly, who do you have?
Your Honor, I have Damari Brown downstairs. I still have to talk to him. We might have to run that preliminary exam, but right now I have Maureen Myers ready to go. We're asking that, well, I'll just give an update for the court on his.
Okay, let me call the case on the record in the matter of the people of the state of Michigan versus Maurice Meyer, file number 23-02984 FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Maurice Myers, who is present standing to my right.
Okay, how are you, Mr. Myers? I'm doing well, thank you. Today's the date and the time that was set for a plea. It looks like our last court date, he had a CMH assessment, and he was gonna have having a screening done. You wanted to give an update?
Yes, Your Honor. The 30th Circuit Mental Health Court did screen Mr. Myers for their program, and they said that he is ineligible. He said he didn't have a qualifying mental health court illness. So at this time, while the prosecutor and I negotiate, we just have this set for preliminary exam.
Oh. April 5th at 9. Do you have any questions for the court today? Okay, any additional matters for the record?
Nothing for the people, Your Honor.
Nothing from defense.
We'll get you a copy of your notice to appear. You can have a seat, okay? Mr. Goodrich, you have a review at 9:30
Yes, Your Honor. Like,
for Alex Harris.
I don't know if you want to go on the record for that.
That's what you just signed.
Status of it.
Is that what the knowledge for?
Yes, Your Honor.
Is Alex Harris here?
He's here, right outside. We're all set, Mr. Harris's matter then?
You're all set, thank you. Mr. Carter,
Yes, Your Honor.
on the record in the matter of the people of the state of Michigan versus Marquise DeMille Carter, file number is 24-00162 FY, appearance for the record.
Assistant Prosecutor Chief Strasky on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Marquise Carter. He's seated to my right.
How are you, Mr. Carter?
I'm fine, Your Honor.
Okay, today's the date and the time that's set for preliminary examination. My understanding is that we are ready to proceed. Any preliminary matters before we call witnesses?
Nothing from the people.
Nothing from the defense.
Okay, you can call your witness.
Thank you. The people call Harvey Cogsworth. And I will go get Mr. Cogsworth. Follow me here.
Raise your right hand first. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can have a seat. Okay, there's a microphone that's in front of you. The lady behind you is my court reporter. She needs to take down everything that's being stated here today, so I need your voice to be loud and clear, and I need your responses to be verbal. We can't do head nods and shakes, okay?
Okay.
You also can't respond to a yes or no with a or a uh-huh, because we don't understand what that is in the record. So if you do that, you'll hear us ask you if that's a yes or no, okay?
Yep. Yes.
If there's an objection from either side, you will stop speaking immediately. I'll make a ruling on the objection, and then I'll tell you if you can give that answer or not. State your first and last name, spell both.
Harvey Cogswell, HARVEYCOGSWELL.
That's what you can proceed.
Thank you, Your Honor. Good morning, Mr. Cogswell. Where were you on December 11th, 2023?
Calendar.
Let me just ask another question.
Okay.
Where do you work?
Paradise Motor Sales.
And do you work there most days of the week?
Yes.
Were you working on December 11th, 2023?
Yeah.
Where is Paradise Motors located?
5520 South Pennsylvania Avenue, Lansing, Michigan. 891.
Is that in Ingham County?
I believe so.
And what kind of business is Paradise Motors?
Auto sales, auto repair.
Does Paradise Motors have surveillance video or surveillance cameras?
Yes.
When you were working on or about December 11th, did you have someone come in and ask to test drive a vehicle? Are there any people from that time period that sticks out in your mind?
There was a vehicle stolen. A vehicle that was put out on the test drive did not come back.
So let's talk about that a little bit. That person who came into the store, did you get to see his face? Would you recognize his face if you saw him?
Possibly.
Is he present in the courtroom today?
believe so, I'm not sure.
The person that you believe to be the man who came in to test drive the vehicle, could you describe where he's located in the article of his clothing?
On the day that he was in there?
Today.
Oh. I had a lot of customers that, like the gentleman sitting right there. When this happened, I think I had 4 or 5 different customers going at the same time, so. It's possibly him, but I couldn't say.
Okay. So when the person who eventually stole the vehicle came into the store, did he, I guess first of all, was there anything notable about his appearance to you?
No,
What did he come into the store to do?
let's drive the truck.
Did he give a name?
Yes.
Do you remember what the name was?
First name was Achilles. The last name I think was Campbell, but I don't remember it for sure.
Okay. Did he give any other personal information?
Yeah, we did a credit application, so address, phone number, social number, that stuff.
And he provided an answer for all of those?
Yes.
And so you said that you need that to run a credit check.
Yes.
So why is that?
We get to look at someone's credit, we have to have them verbally give us the information in order to do that.
And so you ran a credit check.
Yes.
What did you do after running the credit check?
Well, I remember, I could say I had a few customers at the time. The truck we wanted to drive had a flat tire, so I had to wait for the service department to get that done. And once they gave it up, they brought it down, I put a plate on it. And
You remember what vehicle he test drove?
it was a black badge pickup truck. I think it was a 2011.
Okay.
Not 100% sure. Like I said, I had a few customers at the same time.
Would a vehicle, would that vehicle, do you know how much that would cost?
I would say probably that truck was probably priced at $16,000 or $17,000.
When people take vehicles out for test drives, how often do they take, or excuse me, how long do they take the vehicle out for?
If it's just a test drive, 20 minutes. Some people like to take it to the mechanic. It could take longer, but typically if somebody's just going to drive it, it's 15 minutes, 20 minutes.
Did the person who took that vehicle, did he bring the vehicle back within that time frame?
No,
Did he ever bring the vehicle back?
not to my awareness, not to my knowledge.
Okay. Did you or someone from Paradise Motors contact police about this?
Yes.
No further questions.
I have a quick question. You stated that you have a lot of customers that look like the individual in court.
Yes.
What do you mean specifically?
In black vests, self-lancing is a lot, just in the current style, I guess, that I would say, I would guess late 20s. A lot of similar looking people. And I've been selling cars since '95, so I don't necessarily remember them all, especially if I got a few at the same time.
Okay, but do you remember if the person's that's in court, his hair looked like the person that came into?
I don't think so. I
Mm.
think it was a different hairstyle than what this gentleman has right now.
Okay, like a lower haircut or? long?
More like certain type of braid. I don't know how to describe
Okay,
it,
got
but
you.
more
So
of a
different
braided-
style,
Yeah,
different style of lock or braid, right?
Yes.
Okay.
Yep.
You can cross-examine,
No questions. Thank you.
indirect.
Nothing further, Your Honor.
Thank you. May this witness be excused?
Yes, he may.
You may be excused, sir.
Thank you.
Oh, you're good to go. Thank you so much for coming.
Call your next witness.
Okay.
Thank you. The people will call Nancy Hamilton.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. Please state your first and last name and spell both.
Nancy Hamilton, NANCYHAM, excuse me, ILTY.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Ms. Hamilton. Where do you work?
Michigan Department of Corrections.
And what are your duties?
I'm an embedded parole agent.
Were you working as a parole agent on December 12th, 2023?
Yes,
And were you contacted by someone named Matt Finlay?
yes.
Why did he contact you?
I received information that it was over the radio and I contacted Finlay, and he advised me that there was a vehicle that was taken off their lot and not returned, and that the person had a tether, and they wanted me to check to see if it was an MDOC tether, and I did check, and it was not an MDOC tether. Called JSG tether, which is the other area tether in the Lansing area, and gave them the address of the dealership to see if anybody was in that dealership at the date and time of the incident, and there was.
Objection, Your Honor, it's hearsay.
The statement
of the
about,
person that you talked to at the tender company.
okay, well. Is that being offered for the truth of the matter asserted?
No, Your Honor, I would say it'd be offered for effect on listeners for what she does next.
The court will use it solely for the purpose of the effect on the listener.
Thank you.
Thank you.
So after you'd received that information about there being someone with that on GPS tether at that location, what did you do?
I looked up the photograph in Omni is our War Otis, whichever, it's the same picture. And the pictures weren't exactly like, I couldn't identify the person that the name that was given to me by JSG tether. So I searched Facebook for that name and found the defendant's Facebook picture, and it matched the picture that they had from the dealership.
Okay. So stepping back just a little bit, what was the name that came up when you or what was the name of the person that the tether whose tether was shown to be at the location?
Marquise Carter.
Your Honor.
I would agree. Or your objection sustained.
So once you have the name of the individual and you looked them up on Facebook, you said there were pictures on the Facebook?
Yes.
Okay. And why were those pictures significant to you?
It was next to a vehicle and it matched the picture that I was seeing. that the dealership sent.
And the dealership,
Section, Your
in
Honor,
the
we're
video.
talking about photographs, not an evidence. In terms of testifying about what one picture looked like and another picture, if we're going to describe the picture, we need to have that, under MRE 1002.
Counsel.
I would say that she is, she's describing what she saw of the pic, like I'm not trying to offer the picture for the sake of proving anything. I'm just trying to state the,
Well, we allowed the testimony about her contact with JSG for the effect on the listener, and essentially she's laying the foundation to tell us what she did or why she did what she did, I suppose. Your objection is that she's talking about what she did with the pictures she received?
And she's actually describing the similarities and differences between the pictures, Your Honor. So she's talking about the contents of those photos, which I think is admissible.
Okay, she received photos. She's talking about photos she received. I'm gonna overrule the objection. She can continue.
so you said that you saw the photos that,
Yes.
oh, yes or no, just for the record?
Yes.
Yes, sorry. You saw the photos, and in the photos, you said that there was the profile, the person in the profile was standing in front of a vehicle. Do you remember what the vehicle was?
I don't recall without looking at my Facebook.
Okay.
I believe it was a Charger, but.
Okay.
I can-
And did you know or have knowledge of the person in the Facebook account?
He used to be on parole in our office,
And what was his name?
Marquise Carter.
And did you ever see his face?
In a photo or
I guess either or, either in a photo or in
in
person.
the photo, yes.
And would you recognize his face?
Yes,
Is he present in the courtroom today?
yes, he's a good defense.
Can you describe an article of his clothing? Let the record reflect that Ms. Hamilton has identified the defendant.
Right, she's identified the defendant as a person who has a Facebook page with a picture that looks like this man. She's not identified
Correct.
the person that took the car.
Prior, based on the evidence been submitted, she's identifying a picture of a person that she says was previously on parole out of her office. That she saw a picture on Facebook in front of a Charger. I don't know how that identifies the defendant.
I would say that she's identifying the person that she saw the Facebook of, and that she found. She is identifying the person that was in the photo in front of the Charger that she found as a result of looking somewhat based off of where the JSG tether placed him.
Okay, counsel, can you approach?
I have no further questions for this witness.
Cross-examination.
Morning.
Good morning.
So your first attempt to identify someone was through Otis pictures,
Yes,
and those are people that have been in prison.
Prison or probation,
And those are the kind of people that are on parole?
parole or probation.
Okay, and,
If I said parole, I meant parole or probation.
okay. But it was your understanding that this person was actually on parole with your office?
He was on parole or probation. I don't recall which, but it was in Omni,
Right.
an Omni photo.
But the guy in the Omni photo is not this guy, right?
Yes.
You said it didn't look like him?
No, I said that there was different hairstyle. It was, I couldn't identify him based on that from the surveillance footage.
Okay.
From the lot. And that's why I wanted a more updated picture. Because Otis, the picture, if I recall correctly, was from several years ago.
Nothing further.
Okay, the photo that you saw, you said in Omni, you personally dealt with that individual before?
Not personally, no.
Oh, someone in your office?
He was supervised by somebody in the Department of Corrections.
Okay, so you would not ever have had any personal engagement with anybody identified as Mr. Carter or the person that you saw in Omni?
No,
Okay. Any redirect or cross-examine based on that?
No, Your Honor.
Oh, thank you.
Okay, may this witness be excused for now?
Yes, Your Honor.
Okay, you may be excused. Thank you. Counsel, do you have any other witnesses today?
Not today, Your Honor.
Okay. Assuming you're seeking an adjournment based on our brief consultation.
That's correct, Your Honor.
Okay, so you subpoenaed a JSG witness to appear.
Yes, we subpoenaed Mr. John Hayes to appear. And as best I can tell from our system, he was properly subpoenaed, so.
Okay, John Hayes is usually pretty good because we subpoena him for or to appear for a number of things, especially for people on probation. Not sure why he's not here, however, I look outside and it looks like a snow globe, which might have caught some people off guard. That could be or could not be the issue. Mr. Abbott?
Well, we object to the adjournment, Your Honor. There's been 2 witnesses. There's been no identification. And there's been no real proof the car's been stolen or that Marquise had any possession of it.
We don't need any proof at a preliminary examination that the car's been stolen. We have testimony that a car was stolen. We just don't have evidence to a probable cause standard that this person was the one who stole it. That's what we don't. We definitely have evidence that a car was stolen.
Okay.
I don't need any proof that it was stolen, just some probable cause. And then I'm assuming JSG, it will be the missing link for the evidence that I couldn't admit under that witness because they were the ones supervising the tether. And they were probably subpoenaed. That's outside of the prosecutor's control. And we don't know why Mr. Hayes, who's pretty reliable, would not be here today. What I do know is that, or what I could assume, and I'll ask on the record, if this case is dismissed, does the state intend to reissue the charge?
Yes, Your Honor.
It's not in the interest of judicial economy to grant the dismissal then, because all they're gonna do is reissue that before he can get back to Ingham County today and get released. So with that being said, I'll grant your continuance and we'll get your new date.
Thank you.
March 7th at 10. March 7th at 10.
So,
Any additional matters for today's update?
Nothing for the people.
nothing for the defense.
Okay, you're all set for today. Ms. Robinson had someone that needs it. Is it a plea, Ms. Robinson, you said?
Yes, Your Honor, Mr. Caswell, he's in custody.
We can bring Mr. Caswell up.
Okay. Your Honor, Mr. Carter asked me to address the issue of bond.
You can, back on the record, you can proceed.
He's been in custody for 3 weeks. The allegation here does not include any violence. Stable member of the community. I don't know what his history is. And that's the court for a personal recognizance.
I don't know what his history is either. So that's an major factor into whether or not he's gonna get a personal recognizance bond. He was granted a bond of 7,510%, which considering the charges in this particular matter, count one, identity theft, 5 years and or $25,000, false pretense, 5 years and or $10,000, or 3 times the value of the property, motor vehicle unlawful driving away, felony 5 years, and then a habitual offender second offense, a notice which enhances the sentence. I think that that was more than reasonable, and whoever, I should say whoever, it looks like Magistrate Milmore arraigned him, and she at the time had his criminal history. Does he have any other matters pending?
I believe he's currently on bond out of Dragon Chuck's court.
Do you have a matter pending before Judge Dragonchuck?
Yes, sir.
What's the bond there?
I'm on bond right now.
What was the bond?
It was 15,000
Cash surety or PR?
cash shirt.
Okay, so you posted a cash surety bond for 15,000. Any other conditions on that bond?
Just to tell it.
Oh, that's interesting.
Black.
Mr. Blackman is your attorney on that case? Oh, okay. And you were on bond at the time of the alleged incident?
Yes, ma'am.
Okay, bond is denied.
Thank you.
Bond motion is denied. His bond is still 7,510%, which is more than reasonable because he would have allegedly have been out on bond and on GPS tether at the time of this alleged incident occurred with, which ironically involved somebody on a tether.
Thank you.
Thank you. You're all set. Anybody else have anything that is ready to go right now that's not someone that's in custody? No. Mr. Etheridge had a,
Proceed on Kaylee Thibodeau. I just need to run down the hall.
oh, you're hearing the link. I was just about to ask about that. Okay. Very good. You can grab him, please.
Yeah, Mr. Etheridge was just about to go on the record and Judge Buchanan's.
Oh, he's going on the record with you. Okay, got it. No worries. Mr. Caswell.
Yes, Your Honor, can I approach with the plea sheet?
Yes, please. On the record, in the matter of the people of the state of Michigan versus Justin Wayne Caswell, I have found number 22-03524.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Caswell.
Okay, how are you, Mr. Caswell? I couldn't hear you.
I'm right.
Okay, today was the date and the time that was set for a preliminary examination. My understanding is there is a plea that people are offering you, Mr. Caswell, to plead guilty to an added count 2 of use of a controlled substance under Michigan Compiled Law 333.74042B. Is that your understanding of the plea offer?
Yes, Your
And did you want to accept that offer today? Your advice of rights.
Well, I have an advice of race here, but there wasn't room for a signature or anything.
Is that the new one?
Those are the new ones. There's no
I don't
line.
know why.
So, but I did review it with him.
Yeah, we just got new ones. We need to let them know that. I don't know why that is. Let me have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. Okay, you understand the rights that's listed on that advice of rights? Okay, you wish to give those rights up today? Okay, you have the right to the presumption of innocence. So you're innocent until proven guilty. Did you know that? Can you speak louder so that the,
Yes, ma'am.
thank you, because we have to hear you on the
I'm
record.
sorry.
Okay, okay, you understood that you had the right to the presumption of innocence?
Yes, ma'am.
You have the right to require the prosecutor to prove your guilt at a jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at that trial and not have silence be used against you. You have the right to confront and cross-examine in court any of your accusers or any witnesses called to testify against you. You have the right to call your own witnesses to trial to testify on your behalf or to present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights? Is there anybody making any threats to you to get you to give up those rights?
No,
Has there been any promises made to you in exchange for you entering a guilty plea?
no, ma'am.
Are you currently on probation or on parole?
No,
You understand that a guilty plea could result in a conviction that may have impact on travel or immigration status that you may seek or be seeking at this time?
I do.
Okay, and so you also understand that a guilty plea could also result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application.
Yes, ma'am.
As to the added count 2 of use of a controlled substance, how do you plead? And are you pleading guilty because you believe you're guilty? Factual basis, counsel.
On September 16th of 2022, were you at the area of 1221 Keystone Avenue in Lansing, Michigan? Okay, and that is in the county of Ingham, state of Michigan?
Yes,
Okay, and did you have contact with the law enforcement officer at that time?
I do.
And at that time, you were arrested for having a warrant out of county, correct?
Yes, ma'am.
And you had a backpack on you at that time, correct?
Yes.
And inside of that backpack, well, did the officers do a search incident to arrest in the backpack? Did they search your backpack? Okay, and did they find heroin in that backpack?
Yes, ma'am.
Did you know it was heroin?
Yes, I did.
Okay. Did you have a prescription or any legal reason to own that?
I did not.
Any questions?
No, Your Honor.
The court is satisfied with the factual basis. I will accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing April 18th at 9 a.m. You need to undergo a substance abuse assessment prior to that sentencing. You're being held on something other than this, correct? Okay, what are you being held on?
He has another city case here in front of your honor, Judge, but I believe that the bond that is holding him is actually for this case. So I would ask for a personal recognizance bond at this time.
I'm sorry? Where? It's on the 8th, I said it was dismissed. That's why it's the bond. I dismissed the bond violation at last week's hearing because he has another matter that resulted from that. Looks like he was remanded for failure to appear. Bond was originally 3,000 personal recognizance. Let's see. You were supposed to be here December 28th, 2023. You didn't appear. What is going to make me believe you're going to appear all the way in April?
I didn't appear, so I was in the hospital.
Okay.
That's
Okay.
I have all the documents.
What's your address?
3908 Circle Drive, Mason, Michigan.
Phone number?
There's two of them. I got the 39 or 3959 or the
359-9998.
9998. Yes.
And there's another one?
Yeah, I have a secondary one. Like if there's a reason you can't reach me on that one, 517-588-9033.
Okay. Bond will be reinstated at 3,000 personal recognizance. You need to report to probation, which is on the 5th floor of this building, no later than Monday at 10 o'clock in the morning, okay? Actually, is Monday a holiday?
It is.
Okay, you won't be reporting on Monday because it's a holiday. No later than Tuesday.
Yes, ma'am.
And they'll get you set up so that you can get prepared for your pre-sentence interview, okay?
Yes, ma'am.
Do you have any questions?
I do not.
Okay, any additional matters for the record today, council?
Just briefly, what time was the sentencing set for again?
Oh, 9 a.m.
9 a.m. Thanks. Thank you.
No problem. And you can appear via Zoom for your sentencing, so long as you followed all my orders prior to that. Otherwise, you might as well appear in person if you didn't get that pre-sentence interview completed, okay? Okay, do you have any questions?
No, ma'am.
Okay, we'll see you on April 18th. Well, you'll see me on April 18th. You'll see probation when?
Right after the holiday.
On Tuesday, not on Zoom, in person.
Oh, in person.
You gotta come in person and
Before.
check in with them to the 5th floor.
Before on person.
Yep. Thank you.
Appreciate it.
Okay, that was Caswell. And then you did hear us already.
She
Oh,
doesn't need to be
okay.
brought up.
Not need to be brought up.
My understanding was she wasn't here.
Yeah. Oh, she's
She's
not
not
here.
here.
Oh, my
And
bad.
there's that.
That was my understanding.
On the record in the matter of the people of the state of Michigan versus Haley Thibodeau. Give me one moment. You need to know who to bring up next. Who are we running next? Johnson?
Johnson or we'll bring up Johnson.
I don't see Mr. Nichol.
He's in the hallway.
Mr. Nichols ready on Johnson? We'll bring Johnson up. Okay, on the record in the matter of the people of the state of Michigan versus Kaylee Ann Thibodeau, file number 23-01343 and 23-02379, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Attorney Derek Etherton, also public defender on behalf of Ms. Thibodeau, and I'm assigned to the felony case, Your Honor.
Assistant Public Defender John Lee, on behalf of Kaylee Thibodeau, I am assigned to the misdemeanor case.
Okay, today was the date and the time that we reset these for a review. She was supposed to be screened for drug court, and the defendant is not present today in court. You're waiving her appearance for these purposes.
Yes, Your Honor, she is in Clinton County Jail. Your Honor, everything got put on hold because she was sent to forensics by the Clinton County court in her felony file there. Just to give the court an update, my understanding based on what Mr. Tamal has told me recently by email is that she had been found competent. She has waived up to circuit court. His intent is for her to plead to an attempt receiving and concealing with guidelines of 0 to 6 months. She should be sentenced sometime around, or please sometime between now and the end of March, he was saying. His understanding is that she would have time served at her sentencing and then be on probation for 2 years. They did get her bond changed so she could PR out to go to inpatient treatment. In regard to drug court, I looked back through my emails and it appears she was approved back in the end of November or December, but then she went to forensic, so that was put on hold. I did email drug court for an update. I believe they're at max capacity, so I don't know if they will allow her in there or not. So we're hoping to hopefully get her into drug court or get some resolution that takes into consideration that she does need treatment, wants to resolve it in a fashion as if she would have been in drug court.
Okay, so you need some additional time to work through that.
Yes, Your Honor. So we'd ask the court to set it out for a PCC and then a PE for the felony. And I'll let Mr. Lee discuss his thoughts on the misdemeanor.
We do anticipate that some of the misdemeanors may be included in a global resolution on the felony case, Your Honor. So we would ask that the misdemeanor be set out at some time after the preliminary exam.
That one doesn't matter. I don't think it does.
PCC April 4th at 8:30.
April 4th at 8:30 for probable cause conference. Exam April 18th at 8:30. April 18th at 8:30 for exam.
Thank you, Your Honor.
No problem. And then the pretrial can be April 23rd at 8:30. April 23rd at 8:30 for pretrial. Any additional matters for the record?
Nothing from the people.
Nothing from the defense regarding the felony, Your Honor.
Nothing for the misdemeanor, Your Honor.
Thank you, you're all set.
Thank you, Your Honor.
No problem.
Yeah.
On the record in the matter of the people of the state of Michigan versus Ray John Jacoby Johnson, file number 23-02932 and 23-03166. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Scott Nichol on behalf of Mr. Johnson, who's present and seated to my right.
Okay, today's date and the time that was set for preliminary examinations, and we're ready on both.
Yes, Your Honor.
Okay, any preliminary matters?
Nothing for the people.
Your Honor, I would just ask for a sequestration order so that the various witnesses in the case are not speaking to each other about their testimony.
Okay, sequestration order is granted. How many witnesses do you have on? Are you running these cases together or separately?
I was going to run them separately.
Okay. Which one are you starting with?
So on 23-02-932, I have 3 witnesses.
Where are those witnesses?
Officer Rob Forbes is in the jury room, and then Larry Bowie and Shantae Hobson are in a conference room.
Okay, we'll get them sequestered. We need security to come down here. And the sequestration is ordered. You can call your first witness.
Thank you, Your Honor.
Simmons Court.
Yeah.
Oh, I can't see back there. I'm sorry. Oh, thank you. I just need someone to go. I just needed someone to go and separate the 2 witnesses in the room.
Oh, okay. They're down there. There's just one in here. Second conference. I think that she just went to do it.
Let's get the witness, so I'll just make sure that she knows that.
I didn't realize Nathaniel was here. We're all set. Thank you. I can't see back there.
So you want to come over here? You can be able to do the step up. Is that okay?
No,
Just
right
have to-
behind you, there's the stand.
I just want to make sure that the ledge wasn't gonna be a problem.
I need you to raise your right hand first. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you. You can have a seat.
So you want to sit in that chair? Real quick? There's a microphone, so they'll be able to hear me.
Okay, there's a microphone that's in front of you, and the lady behind you is a court reporter. She has to take down everything that's being stated here today, okay?
Okay.
So I need your responses to be verbal. They need to be loud and clear. Is that a stocking cap on your head? I need you to remove it. Thank you. Okay, all your responses need to be verbal. You can't do mm-hs and uh-hs or head nods and head shakes, okay? Also, if there is an objection from either attorney, you will stop speaking immediately so that I can make a ruling on the objection, and then I will let you know if you can give that response or not, okay? State your first and your last name and spell both.
Larry Bowie.
Spell both. Spell your name.
Larry, Larry, Bowie, Bowie.
You can proceed.
Thank you, Karen. Good morning, Mr. Bowie. How are you doing today? So I want to go back to an incident that happened this fall, okay? Do you remember an incident occurring on September 21st, 2023?
Sure, yes, ma'am.
On that date, were you at Tulin's delicate, or the Tulin's liquor store?
Yes, ma'am.
Is that liquor store, is that in Lansing?
Yes, ma'am.
Is that Ingham County,
Yes, ma'am.
state of Michigan?
Yes, ma'am.
So what were you doing at Tulin's on that day?
Buy me a drink?
Buying a drink?
Yes, ma'am.
Who was with you?
My woman, my girlfriend,
What's her name?
Shantae.
Shante? So when you were in the store, did you, or so you said you were buying a drink?
Yeah,
Did you go and select a drink? Or
yes.
did you shop and then were you, I guess, did you try to check out?
No, I was talking to somebody I knew first
Oh, okay,
in the store.
right. And who is that?
Name is Larry. Name is man, don't know his name.
Okay. And Larry's a friend.
Yes.
Did something occur when you were trying to check out?
Yes,
Can you describe what happened?
I know. Well, I can remember I went to get in line, people didn't try to get in line. They say I knew I got pumped and on the floor. You guys stand on me talking about call me another.
And I'm so sorry, could you repeat that last part?
The guy standing behind me must have been the one punch me, him over there talking about call me another. And then people in the store, remember people in the store say he wasn't talking to you, he wasn't talking to you.
Okay. So before you were hit, did you see the person who had hit you?
No, because I was hit from behind.
You was hit from behind.
Yes, ma'am.
And when you were hit, you said you'd fallen down
On the floor, yes, ma'am.
onto the floor. Did you, or what happened after you were on the floor?
Raised up. It's French, I ever get up, I raised up, I see this guy stand over me, talking about call me another.
Could you see his face?
Yes, I did.
Would you recognize him if you saw him
Yes,
today?
I do.
Is he here in the
Yes,
courtroom?
ma'am.
Could you describe where
Right
he,
there.
could you just verbally, could you describe where he's sitting in an article of his
Yeah,
clothing?
sitting by this guy right here.
And what's he wearing?
Red shirt with everything.
Let the record reflect that the witness has identified the defendant.
Any objection to identification?
No objections for the purpose of preliminary exam.
Identification is noted.
So he was standing over you and looking at you.
Yeah,
Did he do anything after that?
not the money, I don't know. He must have left, because my girlfriend had me get up, I didn't see him, they say he kept on the bike and took off.
The items that you were checking out, did you purchase those items?
Yes, I did, and I was
Sorry,
told he took some.
he took them.
Yeah,
Objection, Your Honor, hearsay.
Um,
He just said I was told he took something.
I'm not
Okay,
both.
so when I said, I gave you some instructions, I said if there's an objection, you stop speaking. Did you want to respond? Is that being offered for the truth of the matter asserted?
it was, but can I, if I may just rephrase?
Absolutely, objection sustained. You can rephrase.
So, you said that you didn't see anything, but when you, after the assault, were items missing? The items you'd purchased, were they missing?
Yeah,
And you had had those items before being hit.
yeah,
Did you see the defendant leave the store?
no,
And why not?
I was on the floor, unconscious.
Oh, you're unconscious. Okay.
Floor, speaking unconscious.
After the assault, did you speak with police?
Yes, I called.
And did you have to go to the hospital?
Yes, I did.
And what type of treatment did you receive?
Gave me a shot, put a thing on my neck, then they gave me x-rays, make sure I get no blood from me, whatever.
No further questions.
Processing.
Mr. Bowie, what we're talking about, said it happened back in end of September at Tulin's liquor store, correct?
Correct.
Okay. And said you were struck from behind, correct?
Correct.
So you don't know that the person that you were looking at when you got up, you don't know that that was actually the person that hit you, correct?
I didn't see him.
You didn't see him hit you. But somebody hit you, you were looking up, there was this gentleman yelling at
True.
you. Okay. And then you didn't see him leave the store and you didn't see him take
I did
anything.
not see him.
And you didn't see him take
I did
anything.
not see him.
I have no further questions.
Redirect.
No redirect, this witness may be excused.
Thank you. You may be excused, but I need to first advise you that there's a sequestration order. So that means you're not allowed to discuss any portions of this testimony with any other witness, okay?
Ma'am,
You may be excused, sir.
thank you.
You can call your next witness.
Thank you. The people will call Shantae Thompson.
You're coming up to right here. When you get there, you'll stop and raise your right hand. When you get right there, you'll stop and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yeah.
You can have a seat, ma'am.
Okay.
Okay, there's a microphone that is in front of you, and the young lady behind you is my court recorder. She has to take down everything that's being stated in the courtroom today. So your responses must be verbal and they must be loud and clear, okay?
Yes.
If there's an objection from either attorney, you'll stop speaking. That gives me an opportunity to make a ruling on that objection, and then I'll tell you if you're allowed to give that response or not, okay?
Yes.
Okay, state your first and your last name, and then I need you to spell both of those names.
Shante, Shante, Chante, middle name Nicole, Nicole, last name Hopson, Hopson.
Proceed, counsel.
Thank you, Your Honor. Good morning, Ms. Hobson.
Um,
Do you, were you at Tulin's Liquor Store on September 21st, 2023?
Yes.
And who were you with?
With my boyfriend,
What's his name?
Larry Boyd.
What were you doing at that store?
We was in there buying us something to drink, a couple of beers.
Did something out of the ordinary happen that day?
Yes.
Can you talk about it?
We was sitting there in line, he was talking to one of his friends, he was playing around, and all of a sudden, he had just all of a sudden just hit him from nowhere, he fell to the ground.
Did you see the person who hit him?
Yes,
And did you see his face?
yes,
Did you recognize him?
yes,
Is he here today?
yes,
Can you describe where he's located in an article of his clothing?
red,
He's wearing red,
yes, right there.
right there. Let the record reflect that the witness has identified the defendant.
Any objection?
No objection for the purposes of preliminary exam.
Identification is noted.
So you said that he hit
Yeah,
your
just
boyfriend?
hit him
He hit him? Where did he hit him?
in his jaw.
His jaw?
Yeah, and Larry fell right to the floor, he was knocked out for a minute.
He was unconscious?
Yeah.
What did the defendant do after he hit him?
It was in shock. He was in shock, you know,
Or what did the man who hit him, what did he do after?
nothing.
He didn't do anything?
You talking about my boyfriend?
No, I'm so sorry.
Oh,
The man,
oh.
the,
Confused, it's my first
It's
time.
okay. no, it's okay, it's nerve
The
wracking.
one that hit him,
Yes,
he was just sitting there talking about, bitch, do it again. Then we had the stuff we got on the counter, he just stuck it,
okay, he took
and
it.
just left out the store.
And did he,
Just snapped out.
was that, had you purchased those items? already?
Yes, we paid for it and everything.
And then he took those items?
Yeah, so left out the store, talking about y'all bitches, and just snapped out. Nowhere. Scary reaction.
Yeah.
Nowhere, nobody, so,
Yeah, and had you met the man who hit him before?
no.
No.
Seen him around.
Okay.
Yeah.
No further questions.
Cross-examination.
So when this man hit Larry, where were the two of you standing?
standing side by side. It just happened from nowhere. We were sitting there paying for our stuff and all of a sudden it just, wow.
So standing on the counter?
Yeah,
Were you looking at the clerk?
yes, we both was, looking like, paying for our stuff. It just happened from nowhere.
Okay. Did you actually see Larry get punched?
Yeah, yeah,
Were you-
everybody's seen it in the store. It's on camera.
Okay.
Yeah,
But did you actually see it as it happened?
yes, I did.
But were you looking at the clerk or were you looking to the
I couldn't
side?
help but see his face. He was the only one standing beside, behind us, close by.
Okay.
Yeah,
So he was behind you, but when Larry got punched, what direction were you facing?
looking at the clerk, looking around. I mean, you couldn't help but see that he did it,
Okay. And then you said Larry fell to the ground?
Yeah, fell to the ground.
And then this gentleman was yelling?
Yeah, bitch, this called somebody else a bitch or something like that. It just, like I said, he took our stuff and just left out the store. Just snapped out like he wasn't in his right mind. I don't know.
And he left the store?
Yeah. And we called the police. They eventually called him and said that.
Okay. Did you give a statement to the police?
Yes, I did. I went to the hospital with Larry and everything.
Okay. Did Larry give a statement to the police?
Yes, he did.
Okay. And you said, how many times do you think you'd seen this individual before that day?
I mean, it's in the neighborhood we stay in, you can't help but see, we always see them riding a bike around, That's my bike.
Had you or Mr. Bowie ever had a specific
No.
interaction with him prior to that day?
No.
I have no further questions.
And I also have no further questions.
I have a question. Where's Tulin Liquor Store?
It's on the north side.
What street?
What's the Saginaw?
Okay, thank you. Can this witness be excused?
Yes, Your Honor.
There is a sequestration order, so that means you can't discuss any portions of your testimony with any other witness, okay?
Okay,
You may be excused.
thank you.
You're welcome.
Yep, you're good to leave. Yeah.
Have a nice day.
Thank you. You can call your next witness. If you have one.
Actually, Your Honor, I don't need to call the final witness.
Okay, is the defense calling witnesses today?
Defense has no witnesses at this time.
Okay, argument.
Thank you. The defendant in this case, Mr. Johnson, is charged with assault with intent to commit robbery while unarmed. And the elements for that are that he assaulted the victim with force or violence, that he, and as such, he attempted or tried to do immediate injury, or that he committed an act that would cause someone to fear that. And that also the excuse me, misspoke earlier. My apologies.
Sorry, I had the wrong file. I was like, oh boy.
No, I just misspoke.
Okay.
My apologies. Mr. Johnson is charged with unarmed robbery in this case. And for him to have completed that, he needed to use force or violence against a person in the course of committing the larceny. And in this case, that would be the alcohol that Mr. Bowie and Ms. Hobson had just purchased. The testimony from Mr. Bowie is pretty clear on exactly what he experienced. He was shopping, he was out with his girlfriend, he had purchased some alcohol, he was at the counter checking out, and then someone punched him from behind the head, or punched him from behind. When he was lying on the ground after he came to, he was able to see the defendant and was able to identify him. And also his testimony established that this took place on September 21st at Tulin's Liquor Store, which is within Lansing, Michigan, Ingham County. The testimony from Ms. Hobson corroborates what Mr. Bowie said occurred, and that the defendant in this case, who she was able to clearly see and identify, attacked Mr. Bowie using force or violence by punching him in the jaw or the back of the head area, and then did so in the course of committing a larceny by stealing the liquor that they had just purchased. The elements have been met, and as such, people ask the court to find this case over as charged.
Mr. Nickel.
Your Honor, at this time, the defense would ask the court not to bind over the matter on the one count of unarmed robbery. The testimony clear that Mr. Johnson certainly, the individual identified by Mr. Bowie and Ms. Hobson as Mr. Johnson was in the store yelling, suddenly assaulted Mr. Bowie. And then once he had allegedly struck Mr. Bowie, continued to yell at him about say something again or call me another, I believe is what Mr. Bowie was saying. And then following that, it's alleged that he took some beer. And so I would ask the court to not bind over an armed robbery. I don't know.
Why?
I don't know that there's sufficient evidence that the assault was a part of the robbery. They appear to be two separate crimes. I ask the court not to bind over at this time, but otherwise leave it to the discretion.
Why does the assault have to be a part of the robbery? It's unarmed robbery.
It's the assault has to be in the course of committing the larceny.
He was charged in an unarmed robbery. The only thing they need, we don't even talk about assault today because that's count 2, which is a misdemeanor.
An unarmed robbery is that he committed in the course of committing a larceny, used force or violence against a person. And my argument is that the assault was separate and then the robbery, the larceny was accomplished without the use of force.
How do we know that the assault was separate?
I'm asking the court to just look at the testimony of the witness.
Well, we had testimony today, and today was the date and time set for preliminary examination. So the burden is on the prosecutor just to provide me with probable cause that a crime was committed and probable cause that this defendant committed the crime. It's not a trial. They don't need to prove the elements beyond a reasonable doubt. It's a very low burden. This information is for your benefit, Mr. Johnson. Do you hear me? Is that a yes? Okay, and so the testimony of Mr. Larry Bowie, was that on September 21st or on or about September 21st, 2023, he was at the Tulin's liquor store, which based on the testimony of Ms. Shantae Hobson, is in the is on Saginaw, but both of them testified that it was in the city of Lansing, Ingham County, and he was with his girlfriend. They were getting some beverages that he was hit from behind while he was in line. He identified this defendant, Mr. Johnson, as the individual that hit him from behind. He said he didn't necessarily see who hit him. However, when he was on the ground, he looked up and the defendant was, the person he identified, the defendant was standing over him yelling, "Call me another one." After the assault, the items that he had purchased were gone. He testified also that there was a period of him being unconscious and his inability to see the defendant leave. We had testimony from a Shantae Nicole Hobson, who testified she was with her boyfriend, that being Mr. Larry Bowie, that they were buying drinks at Tulin Liquor Store, city of Lansing, Ingham County, state of Michigan, making venue before this court appropriate, that she identified and personally witnessed the defendant hit her boyfriend in the jaw, that her boyfriend Larry fell out, and that the defendant proceeded to blurt out expletives to her boyfriend and took off with the items that they had on the counter that was purchased. In order to prove this at trial, the people would need to prove for robbery beyond a reasonable doubt first that the defendant used force or violence, that is assaulted or put in fear, the person in this case being Larry Bowie. Second, that the defendant did so while Mr. Bowie was while Mr. Johnson was in the course of committing a larceny. A larceny is a taking or movement of someone else's property or money with the intent to take it away from the person permanently. And so we have testimony here that there was an assault out of nowhere, is what Ms. Hobson said, that she identified knowing the individual or being familiar with him from being in the area, that it was an incident that she believed to be out of nowhere, and that her boyfriend was assaulted and that the items that he purchased was taken. There's a sufficient basis for probable cause for count 1 robbery unarmed that will be bound over to the circuit court. Count 2 will accompany the first count over to the circuit court. The bind over date is going to be February 28th. That's the date the circuit court will get the file from the district court. Are we ready on our next case?
Yes, Your Honor.
Yes, sir.
Thank you. You can call your witness.
Thank you. The people will call Mr. Mark Lowry.
Right here.
Over here.
Yes, sir. And then when you get to the step, you'll raise your right hand. You face me. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat, sir. Okay. There's a microphone in front of you. We have to hear everything that comes out of your mouth because the lady behind you has to take a record of that, okay?
Yes, Your Honor.
So all your responses must be verbal. They must be clear. You can't rely on head nods and shakes, or you can't say, because we don't know what that means, okay?
Yes, Your Honor.
If there's an objection from either attorney, you'll stop speaking. I'll make a ruling on the objection, and then I'll tell you if you can give that answer or not.
Yes, ma'am.
State your first and last name, spell both.
Mark Lowry, MARKLOWRIE.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Mr. Lowry. How are you doing?
Good.
So I want to draw your attention back to September 6th, 2023. Do you remember that day?
Yeah. Yes.
And were you at Tulin's liquor store on that day?
I was walking by to the parking lot. Yes, ma'am.
Do you know the address of Tulin's?
No, ma'am.
Is it in Lansing?
Yes.
Is that in Ingham County,
Yes.
in the state of Michigan?
Yes.
So you said you were walking by Tulin's on that day.
Yes.
What happened that makes that date stand out to you?
I was walking along with a buddy, went into the store, and I walked on, and all of a sudden I felt like my whole body was gonna give out, and I turned around and noticed the defendant, and he just jumped on me and started pounding on me.
Okay, so you said that you turned around and saw you had said the defendant, but was it someone? Did you know that person?
No, ma'am.
Did you were you able to see his face?
Yes, ma'am.
Would you recognize him if you saw him today?
Yes, ma'am.
Was he here?
Yes, ma'am.
Can you describe where he's located in an article of his clothing?
That gentleman right over there with red jumpsuit, I guess that's what you call it.
Okay. Let the record reflect that the witnesses identify the defendant.
Any objection to ID?
No objection for the purpose of preliminary.
Identification is noted.
So at first you said you felt like your body was going to give out.
Yeah. Yes.
Why was that?
Because the only thing I can figure out, got hit in the head with a rock
Okay.
or something. It just totally stunned me. I was just, it's like all my nerves are giving out. So
And you said you were hit in the head.
yes,
So what happened after you were hit in the head that first time?
he jumped at me and started punching me in the face. And, I could barely defend myself. I just, kind of did this and
And when you say did this, you mean like put your hands up to defend
Yeah.
yourself?
yes,
When he was punching you, was he using, you said the rock or?
no, just his hands.
Just his hands? Okay. When you first felt him hit you, can you describe kind of how that felt?
You mean the very first time?
Yes, we'll start, yeah.
From the very first time, I was just walking along, and all of a sudden, I felt like my whole body was gonna give out, just like had my muscles gave out. And I was just, kind of kind of barely could stand, just put it that way.
And then after that is when he started punching you?
Yes,
Do you know how many times he punched you?
I have no idea. All I know is that when it was done, my whole face was swollen up, both eyes are swollen up and all black and blue, and I had blood running down the right side of my face where I got a gash over my right eye.
Were most of the punches concentrated to your head?
Yes,
And whereabouts on your head?
my whole face.
Whole face? Do you know how long it went on for?
I don't know.
That's okay.
Felt like it was forever, but yeah, I know it wasn't. Maybe 3, 4, 5 minutes, maybe at the most, I guess.
And he was hitting you during that entire time?
Yes.
What did the defendant do after he stopped hitting you?
He ran off.
And after, what did you do after he ran off?
A friend of mine came along and he called the police and told them to send an ambulance to me. And I had, at the time, I had a, what do you call the literature, a bag that held some books I was carrying. And then I had to walk across the pavement and pick up my dentures.
Oh, so were your dentures, did they fall out of your mouth?
Well, I knocked out one of my bottom teeth, which held my bottom dentures in, and my denture came out of my mouth while he was hitting me. So, yeah. Yes.
Did you end up seeking medical treatment?
Yes, ma'am.
And what kind of treatment did you receive?
They took me to Sparrow Emergency. They stitched up my eye. They gave me I want to say it's an MRI, but it's not quite. Where they wanted to see if they did any damage to what kind of damage I had to my face and my head.
Okay, what kind of damage?
And then they did it on my legs too, because at the time when they got to the hospital, I had all kinds of cuts, scrapes on my knees and shit from the gravel from the parking lot. So they took x-rays and I'm pretty sure they took a MRI. I'm not quite sure whether that's what I'm, the medical term.
And when the defendant was hitting you, could you see where he was looking?
At me?
He was looking at you?
Yeah.
Was he saying anything to you?
Not a word.
No further questions.
Cross-examination.
Had you seen this individual prior to that day?
No, sir.
Okay. And so you were walking by and suddenly you felt like your body gave out, you fell to the ground?
I was barely standing up and he came over and started hitting me, knocked me to the ground. So, and then jumped on. He jumped on while I was on the ground punching me.
Did you see anything in his hands when he started punching you?
No.
Okay. And you didn't see him actually hit you with anything?
No, sir.
And when he was punching you, was he from behind or was he?
He was on top of me.
So you were face to face?
Yes.
And then you said you fell to the ground, correct?
Yes.
But you don't know how many times he hit you and you don't know how long it lasted, fair to say?
No, sir, I can't give you an honest answer on how many times he hit me or how long it happened.
And you said he never said anything to you?
Not a word, sir.
And he ran off once he stopped punching?
Yes, sir.
Okay. And you said your dentures had fallen out because a tooth had fallen out?
Yeah, I had dentures on the bottom. Well, I had them on top and bottom. But I had 2 teeth here that was, they held my bottom dentures in.
So it was like partial
Yeah.
dentures and then like metal things that wrapped around
Yes.
2 of the teeth. Okay. I have no further questions.
And I have no redirect.
Okay, I just have a couple follow-up questions. You went to the hospital, you said you had to get stitches. You lost a tooth, and then, did you have a concussion at all?
They kind of didn't say whether I did or not, but I didn't go out of my house for about 6 or 7 days because I just didn't have the strength and shit to do it. That and my eyes were swollen shut, so I couldn't see. So,
Okay, any other injuries?
I had scrapes on my knees and where I was on. I still have the scars from them, and
Okay,
but that was it. Yeah.
okay, any redirect or cross based on that?
No, Your Honor.
No, Your Honor.
Thank you. You may be excused. I'm going to advise you that there's a sequestration order, so that means that you're not allowed to discuss your testimony with any other witness, okay?
Yes, ma'am.
You're free to go, sir. Any additional witnesses?
You're good to go home. Thank you so
All
much.
Are you planning to call any other witnesses?
No, Your Honor.
Okay, any witnesses from the defense?
No, Your Honor.
Argument?
Thank you. This case was charged with the with assault with intent to do great bodily harm with the charge of felonious assault in the alternative. Based upon the testimony here brought here today, we would not be asking for bind over on the felonious assault charge as the testimony did not establish that some sort of dangerous weapon was used in this case. However, the testimony from Mr. Lowry does establish the elements necessary to a probable cause standard for the charge of assault with intent to do great bodily harm. The defendant did physically injured Mr. Lowry. He physically attacked him, and obviously, based off of the extent of the injury that was inflicted upon Mr. Lowry, the defendant had the ability to do so. Mr. Lowry was able to establish that this happened outside of Tulin's liquor store in Lansing, Ingham County, Michigan, on September 6th, and was able to identify the defendant. Mr. Lowry's testimony established that the defendant, through his assault of Mr. Lowry, intended to cause great bodily harm, both by just the extent to which the injuries that he caused, it follows that if someone attacks an older gentleman, knocks him on the ground, and is punching him for Mr. Lowry couldn't give an exact amount of time, but somewhere he estimated about 4 to 5 minutes, that someone who is assaulting someone that severely for that amount of time would be intending to cause some sort of physical injury that would harm the health or seriously harm the health or function of the body. And Mr. Lowry did have to seek medical attention following the assault. So as such, I would ask the court to bind over on the charge of assault with intent to do great bodily harm.
Mr. Nickel?
Your Honor, at this time, I'd ask the court not to bind this over on account of assault with intent to do great bodily harm. Certainly, Mr. Lowry's testimony establishes that that he was assaulted, that he did suffer injury as a result of that, that required him to seek medical attention. However, he testified that he did not see the individual he identified as the person that assaulted him, Mr. Johnson, with any weapons in his hand. Mr. Johnson did not say anything to him while the assault was occurring. And so I'd argue that people did not even establish probable cause to establish what Mr. Johnson's intent was when this assault was occurring. Beyond the mere attempt to commit an assault, I would ask the court to modify the count to 1 count of aggravated assault, as I think the fact that he had to seek medical attention may meet the burden, at least a probable cause burden to maintain to trial a count of assault with an aggravated or serious injury as the medical attention was necessary. But I don't think there's sufficient evidence, even in a probable cause standard, to establish what Mr. Johnson's intent was beyond an intent to commit an assault. Thank you.
Okay, count 1, assault with intent to do great bodily harm less than murder or by strangulation. Michigan jury instruction 17.7 states that at the time of trial, the people would need to prove beyond a reasonable doubt first that the defendant tried to physically injure another person. We had testimony today from Mr. Malklari, stated that he was walking near Tulin's Liquor Store, City of Lansing, Ingham County, State of Michigan, which makes venue appropriate in this court, when I don't know where he started to feel I guess the life leaving his body was giving out is what he stated. And he testified that's when he saw the defendant jump on him out of nowhere. He identified this individual in the courtroom as Mr. Ray John Johnson as the defendant who he saw assault him. Satisfied to probable cause as to count or to element 1. Element 2 is that at the time of the assault, the defendant had the ability to cause an injury or believed that he had the ability to cause the injury. The testimony of the victim or the witness is that the defendant that he was first hit from behind. He doesn't know what he was hit with. And then out of nowhere, the defendant being he got on top of him and proceeded to hit him. All of the assault or the contact being in the victim's head. And the victim described, he said it seemed like it went on forever, but at least 4 to 5 minutes of being hit in the head. I think that a reasonable person could assume that there is an intent there to cause some serious head injury. Third, the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was injury, and the court may consider, or the jury at the time can consider it as evidence in deciding whether the defendant intended to cause great bodily injury. Great bodily injury means any physical injury that could seriously harm the health or function of the body. Again, we have testimony about an attack that is caused or resulted in multiple punches to the alleged victim's head. The victim lost a tooth. The victim testified that he had to have his eyes stitched up. He believed he had underwent an MRI to ensure that he didn't have any, I guess, brain or head injury. He wasn't sure as to whether or not he suffered a concussion, but said he couldn't leave the house for several days because he had no energy, he had lost his strength, his eyes were swollen shut, and to date, he states he still has bruises resulting from those injuries from an incident that allegedly occurred in September of 2023, and it is now February 2024. The court is satisfied that there is more than sufficient probable cause as to count 1, assault with intent to great bodily harm less than murder or by strangulation. That will be bound over along with the other file for the same bind over date of February 28th. Bond in this file 23-03166 FY 50,000 cash surety will continue. Bond and file number ended in 2932. 25,000 cash surety will continue. Additional matters for the record.
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set. Who's that? Okay. There's several other ahead of that one. Yeah, I get right there, but that's up to the prosecutor's office, so they want to go next.
It's fine with the court. I believe Ms. Delvaro has a case that is ready to proceed.
Okay, that's for shots in custody.
Yes.
We can take them up.
Yeah, his.
Okay, we're on the record in the matter of the people of the state of Michigan versus Ja'Cory Mushat, file numbers 20-03598 and 23-03153. Council appearances.
Good morning, Your Honor. Angela Delvera on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Ja'Cory Mashad. He's seated to my right.
Okay, today was the date and time that was set for preliminary examination. I have on file number ending in 3598 CSC second degree. Is that the one we're starting on?
That would be preferable to the parties, Your Honor, yes.
Okay, any preliminary matters?
Your Honor, just to place on the record, the court has already signed an order granting the people's request for special arrangements, which include closure of the courtroom and the people's request to not stream this online, given that there's